Awesome. So hi, everyone. Welcome to Tips for Your Employee Handbook. Today is sponsored by the Monterey County Works. My name is Anna Manzano, and I'm the Digital Media and Event Strategist here at the California Employers Association. Before we officially kick off today's webinar, I have just a couple details to cover with you. As you see, your audio will be muted throughout today's presentation, but there will be lots of opportunities to engage during the session. If you have any questions pertaining to the presentation content, you can type them into the Q&A box at any time. If you're on a desktop, it's along the bottom. It says Q&A with the two bubbles, and we will try to address them as we go. Handouts for this training, those were sent out in yesterday's reminder email. If you need them resent, I'll actually go ahead and drop the file into the chat to make sure that you can download it and immediately access it. Last but not least, we do have a survey because your feedback is very important to us. There will be a 5-question survey. It takes less than 2 minutes. You'll see a QR code at the end of today's presentation, and then it will also pop up in your browser window. And if you could take the time to fill out those 5 questions for us, we share that feedback with our partners at Monterey, and we collectively use that information to make sure that we're providing you with the best resources at all times. So as I mentioned, today's training is sponsored by our partners at Monterey County. And today we have Pearl Sanchez, who is the management analyst there, to share more about the resources available to you.
Thank you so much, Anna. Again, my name is Pearl Sanchez. I am representing the Monterey County Works. And I'm just going to go over services and resources that we provide. Starting with the recruitment, we host job fairs, or job and career fairs. Our next one's going to be on the 21st. All this information, it is on our website at Monterey County Works. We have one on March 8th and on March 22nd. So we also do job boards. So for any employers that are interested in us posting their any positions open that they have, we can do that for them. And other promotional activities that we have. We also have other services such as work experience on the job training, other resources such as human resources hotline, and it's what Anna pulled up right now. The resources and referrals for business solutions, rapid response, employer and employee support during downsizing. And then we have our recruitment videos. Those are personalized videos for any business that's interested in putting their positions out there, promoting their positions. Laura herself does those videos. She edits those videos and personalizes the videos. Again, it is a 30 to 60-second video. So if anybody is interested in that, they can contact Laura, and we're going to be providing that information there. We have the HR hotline, as you guys can see, and employers can ask any questions regarding HR, and your questions will be answered. The number is there on the flyer. And we also have meeting rooms available. So if you need to have a meeting or of some sort, for any employers or any other nonprofits, they are free at the moment. It is at no cost. It is from 8 to 5 Monday through Friday. So if you are interested, please take advantage. Again, the number is going to be provided for you. And that's pretty much it. If you guys have any questions, please contact Laura. And our next webinar is going to be March 6th, Wednesday. So, okay. Any questions for me?
I think you covered it. And most of these slides should be in your handbooks. I did just handbooks. We're talking about handbooks in your handouts about handbooks. But I did just drop the PDF into the chat, as well as the HR hotline phone number. And thank you, Pearl, again, and your entire team for sponsoring today. So now I have the privilege of introducing our trainer today. We have Eli Nunez, who is one of our awesome HR directors. And I know we have a lot to cover today, so it's all yours.
Thank you very much. I'll try to live up to the awesome introduction. And thank you, Pearl. Thank you to the Monterey County Works. It's always nice, teaming up with you guys, presenting with you guys. Here we have the slide with the upcoming webinar. So please make sure to tune in, or if you have any friends that, have their own business, let them know that this service is offered from Monterey County Works so they can log on and join us. With that, today we will be talking about employee handbooks, tips and tricks, best practices. But before we do that, a little more about us. I am Eli Nunez with California Employers Association, and our goal is to provide you as partners and anybody that calls us with peace of mind. So we do that by providing training such as this, compliance solutions, recruiting services, basically a whole suite of HR support for anybody that teams up with us, anybody that calls. Really, we want to help you carry that HR burden so you can focus on all the other aspects of your organization. Having said that, one thing I am not, though, is I am not a lawyer. And even though we do have people with legal experience on our team, we do not give legal advice. If you have any questions of legal nature, we always ask that you consult your legal counsel, your personal attorney, or your business attorney, for attorney-client privileges and other advantages there that we cannot provide. And this presentation should be taken from an educational perspective. We're going to talk about best practices. We may even broach the subject of some laws or regulations, but it is not, once again, legal advice. Well, now that we got the fine print out of the way, let's go ahead and jump into what we will be covering today. So speaking of handbooks, we'll talk about some of the benefits and risks associated with them. Essential provisions, that's things that should be in your handbooks. What is best practices or what is required to be in there. Also, going about how you go about reviewing or editing your handbook. Hopefully, if you do have a handbook in your organization, you realize that it is a living document. It's not something to create once, put it on the shelf, seal it in a crypt somewhere and forget about it. We have to make sure it's up to date because, as you know, laws, regulations, everything changes year to year. So we want to make sure that our handbooks are still compliant. And again, check them at least once a year. We recommend near the end of the year, beginning of the year, when all the laws come into effect to see how they affect our handbook. So with that, let's jump right into some of the benefits of having a handbook. And of course, the first thing is confirmation of at-will employment. As you know, California is an at-will state where employment can be ended at any time for any legal reason by the employee or the employer. So we want to make sure that we are confirming that in our handbook. Hopefully that is in your offer letters if you use them or some other kind of documentation for your new hires, but it is always a good practice to include that in your handbook to make sure it is communicated and understood by your employees. Next one is explanation of policy. So, of course, the handbook, we want to have the general policies in there. We want to make sure that they're clearly written so that they're easy to understand by our employees. The goal is that our handbook is the first place the employees go when they have any questions regarding policies, best practices, procedures as far as, how do they go about filing complaints or that sort of thing. So we want to make sure that it's clearly written, explained, and easy to use. Setting expectations for employees is also very important, and this comes along the lines of things like attendance. What's the expectations for attendance? What's the expectations for how they treat their coworkers, clients, that sort of thing. If you've ever called a hotline and had a conversation with us about writing an employee up or about terminating an employee, you'll know that our conversation always veers towards, were the expectations set? Did the employee know what was expected of them? Did they know that they were running, crossing the line? Were they warned? That sort of thing. So expectations are very important, and the handbook is a great way to set those expectations because usually it's one of the first things you give a new hire. So you're establishing that baseline and letting them know where the boundaries are, which goes along with our next point too, uniformity and consistency. Once you establish that baseline, what your policies are, what your expectations are, you want to be sure that you're enforcing those equally, fairly, uniformly across your workforce, right? One of the worst things you could do as a manager, business owner, supervisor, whatever it is have inconsistency in how you treat your employees. Honestly, that creates, a lot of doubt as to how you do things, and really it weakens your policies or your procedures if you're not enforcing them uniformly or consistently across the board. So again, the handbook can help us with our consistency. Defense to harassment claims. we want to make sure that we establish those expectations as to what is allowable and what is not, what crosses the line into the realm of harassment, and how we go about addressing it. Your handbook should have your harassment policy in it, and also talk about the procedures for reporting any kind of complaint or harassment, as well as some of the remedies associated with it. We listed union avoidance here because it's been our experience a lot of times when there's a move to unionize a workforce, it's usually because employees feel like they're not treated fairly or because they're not being communicated with by their management or ownership team. So having that handbook, again, establishing that consistent baseline and treating everybody equally can help employees with feeling that they are heard, feeling that they're treated fairly, and even give them a path as to how they can remedy some of their complaints or some of the things that they are not happy with. Who can they talk to? Who has the power to do certain things? All these things can be outlined in the handbook and really give the employees an avenue within your organization to air their grievances, vent any complaints, and help to feel like they're able to change things without the need for an outside organization. And finally, the number one thing we like to say with the handbooks is you want to make sure we're setting a positive tone for your business. So the handbook should not be something that you can, figuratively grab and hit your employees over the head with, right? It's not just about holding them accountable. It's not just about punishing them. It's about really, putting out there what your business is about, what the expectations are, and how the employees can thrive within your organization. So we want to make sure we're setting that tone within the handbook so that employees are feel that it is more of a resource than a punishment or something to be avoided. Speaking of avoiding, things that you should avoid with your handbook, of course, I mentioned not following. You know, basically, if we've talked to organizations that when we ask them, do you have a handbook? They said, well, we did put one together a couple of years ago, but we never put it in place. Guess what? If you put a handbook together and never put it in place, you don't really have a handbook. You have a stack of paper somewhere that you did nothing with. So again, making sure you're following it. Once you establish those policies, make sure that they're consistent with what you're doing. Reviewing that handbook, as I mentioned, the handbook is a living document. Things change, laws change, regulations change, your workplace changes, right? Things may not be the same as when you started, when you have 5 people working for you, and now you have 500. So there's a need for new policies to go into place. So make sure that we're reviewing and updating that handbook on a regular basis. We also discourage downloading random versions from the internet. I mean, there are some good templates out there, really good templates out there. And I say that because we have a really good template. But you want to make sure that it's something that's been vetted, something that's been reviewed by a legal professional to make sure it is compliant with the state laws and regulations. And finally, borrowing one. Just because there's a business that's very similar to yours doesn't mean it's exactly the same, doesn't mean their practices are exactly the same. So while you can use something like that as a starting point, you don't want to just grab a random one and put it into place and say, hey, Apple is a great business. We want to be like Apple, so we're just going to copy their handbook word for word. That may not apply directly to what you're doing. So again, borrowing one is something that we recommend avoiding. Now, when it comes time to create your handbook, if you're starting from scratch, uh, I always recommend a good starting point is taking a look at your existing policies, taking a look at your existing practices. Are they working? And if so, do we want to make sure that this is the way we keep going? There may be some policies that you've used in the past that you may discard, and others that you need to tweak a little bit because you're looking forward to see how they're going to fit your workforce. Once you have that good starting point as to what you're going to include in there, it's time to start that drafting process, putting pen to paper, if you will. And this can be the hard part. This is where starting from scratch can be a little difficult. So, looking for a reputable company with a good template may be a good starting point for you, or even working with an organization that could put one together for you. So, and again, ideally, your policies are going to be carefully and clearly worded. In other words, make them easy to understand. Don't write them in legalese so that you have to be a lawyer to decipher them, right? Think of your workforce. How is it going to land? Is it going to be easy for them to understand? Again, the handbook should reflect your existing policies. It should really show what you're actually doing. Once you put that handbook out there, the expectation is going to be that you, as an owner or as a manager, is going to follow the handbook It's going to be basically your blueprint in moving forward with your employees, and that's what they're going to be expecting. So make sure that it reflects your policies. Want to make sure it's consistent with legal requirements, right? You can't just say in your handbook, well, we're only going to give people 2 sick days or 1 sick day when the state law requires you to give more. So again, make sure that it's consistent. That's why it's so important once you have a handbook out there to review it year after year. I alluded to it earlier. Make sure you write it in a way that your audience can understand it, that it's user friendly for them, and that they know where to go if they have any questions. And the last one, maybe the hardest part, make sure it's not a snooze fest. Try to make it interesting. That doesn't mean, liven it up with pictures and colors or anything unless you want to. But that means, handbooks, we want to make them as user friendly and as easy for employees to refer to as possible, because at the end of the day, if you have a good handbook that clearly reflects your policies and what you expect, or what you want your employees to do, it's going to make your job easier. So we want to make it so that employees are not afraid of it, know how to use it, are not bored by it, and don't just receive it once, throw it in their desk and forget about it. We want it to be something that's easily referred to time and time again. Now, one thing we do like to differentiate when you're writing an employee handbook, and we've worked with clients or with members that want us to include everything in there. Basically say, well, we want to include this in there for managers, but this in there for the janitor, but this in there for our production workers, but this in there for this person, this in there for that position. At that point, we're talking more like a policy manual, right? Rather than the handbook. A handbook should have general policies that apply to your workforce as a whole. And while you could differentiate a little bit in there between, exempt and non-exempt employees, or, sales and somebody else, really, if you're going to get into the minute details that way, those really belong in the policy manual. The policy manual outlines procedures, gives you detailed forms, and those are more of guides for managers or supervisors to use for the day-to-day operations. Handbooks should be all-encompassing, cover all your employees, and give the general policies and procedures for your business for anybody that's walking into your doors as an employee. So make sure, again, when you're putting that handbook together, you don't go into so many details or so many, personalized, individualized policies that apply only to one position or to one person or to one small group of people. If you need that much detail, make sure you have that separate policy manual from the handbook. It'll make your life easier when it comes time to update things, right? Because think about it. If it's included in your handbook and you change policies 2 or 3 times throughout the year, you're going to be changing that handbook 2 or 3 times throughout the year, reprinting it or resending it out, having to chase on the acknowledgments, etc., etc. So make sure, again, only include in there what you need to include in there for the entire workforce. If it's a policy or something that applies, for policies and procedures, make sure you have a separate manual for each sector of your workforce that it applies to. Let's talk about what should be in your handbook or some of the essentials for it. So the basics we say, obviously avoiding confusion, only put in there what's required, and we'll talk about best practices and other options, other things to consider putting in there. So before I jump in there, though, some of the familiar things that most of us have heard, especially if we're in the HR realm or as managers, sometimes employees tell us, well, you can't change my job description. You can't tell me to do that. That's not part of my job. Or the next question we hear a lot is, do we have to give a 2 weeks notice? By law, do we have to give a 2 weeks notice? No. If my coworker makes me uncomfortable, what do I do? What's the procedure for filing a complaint? Hopefully you've passed that out. Hopefully that's in your harassment policy. Hopefully it's in your handbook. My favorite, my friend's a lawyer. You have to give me the time off and you have to pay me. Or my other favorite is, well, my friend does HR. They say that's not true. Okay, well, let's go to the handbook and see what that says, right? See what our policies are. Do I get paid for holidays? How much vacation do I get each year? Or what if I don't want to take my breaks? All these are situations that can be addressed in the handbook and that the employee should be able to refer to on there to get the answer before knocking on your door. At the same time, there's certain things that we want to make sure that we include in every handbook. And the first one's a statement that basically says employer can change the terms and conditions of employment without advance notice or cause. It's basically like a reiteration of the at-will statement, right? Stating that the employee can resign at any time, employer can terminate them at any time for legal reasons, of course. Same thing with promotions or demotions. Promotions, demotions, they can be dependent on the employer. If an employee wants to step down from a position, they can make that decision and put in that request. Next one, not subject to change except in writing and signed by the employee and an expressly designated company representative. That's a lot of wordiness that says only certain people can change the handbook. Usually your CEO, your owner, your general manager, whatever it is, but you want to make sure that you put that in there, stating that only one specific person or only certain people can change any of the policies. Because if you don't, otherwise you may have leads, foremen, supervisors, people up and down the management line making up rules as they go. So we want to make sure that you have that in there, that any change to the handbook has to be signed off by a specific person. And finally, that integration clause. And what this means is, if you're renewing your handbook year after year, changing benefits in there, changing vacation, changing policies, you want to make sure that you have a statement that says, this new handbook replaces the old one. Otherwise, if you don't have that in there, you may have employees that say, well, you know what? I like the handbook from 3 years ago better because it gave me more vacation. So I'm going off of that instead of this one. Is it a stretch? Yes. Is it something a lawyer may pick up and run with? Also, yes. So that's why we want to have that statement there that says, this new handbook replaces any previous versions. All right, moving on to the big one, discrimination and harassment prevention. As you know, this can cause a lot of trouble in any workplace. So we want to make sure we have a statement there that says that employment decisions are based on work-related factors. In other words, we're not going to use any kind of discriminatory factors when it comes time to make work decisions. We're not going to terminate somebody because of their gender, or we're not going to demote somebody because of their age or anything like that. So we want to make sure that that statement is in there, right? All our decisions, our employment decisions are going to be based on work-related factors. If we're going to terminate somebody, it could be for performance, attendance, safety violations, company policy violations, etc. It's not going to be for anything that's discriminatory. And of course, we always recommend list all those protected classes in that statement. We'll go over them, and hopefully you got the slides because that list is pretty big for California and growing every year, it seems like. So as far as your harassment policy goes, we want to make sure you have these essential elements in that handbook, and these are straight from the state of California. Statement that says harassment's illegal and won't be tolerated, a listing of all the protected categories, basically a statement that says coworkers and third parties, as well as supervisors, are prohibited from engaging in harassment or discriminatory behavior. So basically, anybody that comes onto your business is protected, but also prohibited from engaging in this behavior. Think about if you have a janitorial staff that's outside, that's an outside company that comes in, or think about, I would say, the person that comes in to fill the Coke machine. They are protected from any kind of harassment, but they are also prohibited from engagement in harassment as well. A statement, the anti-retaliation statement, basically stating that anybody that brings a complaint or participates in the investigation is protected from any retaliation. And finally, the contact information for the state and federal agencies that oversee any kind of harassment claims, the civil rights departments and the Equal Employment Opportunity Commission. That contact information should be in the policy, phone number, webpage, that sort of thing. And they should also be in your labor law posters hanging up in your common areas. So hopefully you got a new one, just to had to sneak in that reminder for you as well. Along the lines too, you also want to detail the complaint process, who they complain to, who they can file a complaint with, how the process, like an overview of how the process is going to work, etc., etc. Now, I mentioned protected classes in the state of California. Here is the latest and greatest list. This year, FIHA has added off-duty and off-site cannabis use to the list of California protected classes. We'll talk about that a little bit down the line when we talk about drug and alcohol-free programs, but that is the newest one. Last year, we added reproductive health choices as well as a direct result of the recent civil Supreme Court decision. So, again, these are all of California's protected classes, and that's why it's so important to update your handbook every year because, again, we're adding to this on a regular basis, it seems like so. And just as a comparison, federal law, Title VII under the Civil Rights Act only has 8 protected classes. As you can see, California has, well, more than 8. So again, be very aware of them. Keep an eye on them year after year to see how they change. Okay. Next essential part of our handbook we want to have in there is deals with any kind of required leave of absence with the state of California. And the newest one, of course, or the newest change is paid sick leave. And hopefully you're aware this one changed as of January 1st of this year. The minimum number of sick days required by the state of California has increased from 3 days or 24 hours to 5 days or 40 hours. That's paid time off and job protection for them to address their own health needs and or the health needs of their family. So you'll notice in their bullet point, be very aware of job abandonment provisions. What's this mean? This means if you have a policy that says if you're absent for 2 days and don't call in, we will consider you to have resigned your position or job abandoned and we will terminate you. Be very careful with that because if somebody has any paid sick leave available and they come back and say, well, I couldn't call in because I was sick, technically, those days that they missed are protected and we cannot take any adverse action against them for taking those sick days. So again, be very careful if you're going to terminate somebody for job abandonment if they have any paid sick leave left in their banks or in the books because it could really nullify those no call no shows. I mean, paid sick days can be almost, I like to call them a silver bullet when it comes to this sort of thing, right? It can protect you from a lot of things. Now, when it comes to how we award those paid sick leave, we could use 3 methods have been identified by the state of California. The first one's the accrual method, where you award people 1 hour for every 30 hours worked. Now, this is the same thing that was in previous years, 1 hour for every 30 hours worked. The only thing that changed this year is the cap. It used to be we could cap it at 48 hours and say they can use a maximum of 24 per year. Well, this year, since the amount increased, we can only cap it at 80 hours and cap the usage for 40 hours per year. So again, you increase the number that you award, so you have to increase the cap and the amount of usage. The second method is the lump sum, and this one kind of simplifies things, right? In this one, you just give everybody, you know, their full 5 days or 40 hours, whichever's more, all at once. You just load up their bank, usually at the beginning of the year, sometimes use their anniversary date, whatever it is. Nice thing about that is once you award that amount, a lot of people shied away from that because they said, well, what if I have a new hire and I give them the full 5 days and they quit, after 1 week and they used all 5 days? Well, nice thing about that is the state says, okay, well, you can give people 5 days or 40 hours, whichever's more, and make them wait 90 days after a date of hire to use it. So that's, a little protection for us as employers. Um, Again, when it comes to sick time, paid sick leave is not typically not paid out when you terminate somebody. As you know, we have to pay out vacation when you terminate somebody, but paid sick leave is not something that we have to pay out unless it's part of the PTO plan. And if you do combine sick and vacation into one bucket, the thing to keep in mind is that all the protections from vacation and all the protections from paid sick leave apply to that bucket. So it could be a little more complicated. I mean, it's something that we told people to really think about if they're going to combine it that way. On top of that, if you do combine it that way, the state also gives us requirements as to how much PTO has to be available to them after 120 days. So be very, very careful if you're using that combined plan, especially if you're doing the accrual method. Give us a call on the hotline to make sure what you're thinking of doing or what you're currently doing is compliant. Now, when it comes to sick time too, there are local ordinances. I'm talking about cities, municipalities, counties that could affect paid sick leave. Now, I guess one of the good things about increasing paid sick leave to 5 days or 40 hours is that the state pretty much caught up to some of the more generous counties or cities, if you will. I believe it was San Diego would already had 5 days or 40 hours before this, a couple other places. So this kind of puts everything on the same level as far as awarding the paid sick leave. However, some cities or some counties can have different caps or rollovers associated with them. So be aware of where your employees, if you have any local ordinance where your business is located, but also if you have remote employees or if you send employees to other cities or areas to work, they could be subject to those protections as well. And I'm thinking construction companies, I'm thinking landscapers, painters, or remote workers. If you have a remote worker that lives, say, in San Francisco or San Mateo or Emeryville or something, they could be protected by some of these local ordinances. So again, make sure you're aware if you have remote employees of where they live, or if you send employees out to other cities, make sure you're aware of those requirements so that you are compliant with them. All right, next leave of absence we have is pregnancy disability leave, and this applies to employers that have 5 or more employees in the current year or had 5 or more employees in the past year for 20 or more consecutive weeks. A little complicated, right? So basically 5 is your magic number when it comes to pregnancy disability leave. Keep that in mind. A lot of these protected leaves of absence are dependent on how many employees you have or had in the previous year. Basically, for pregnancy disability leave to apply, a healthcare provider has to certify that the person cannot perform one or more of the essential functions of their job. So in other words, for an employee to have to be on pregnancy disability leave, their doctor has to place them on it. They can't just come in and say, hey, I want to go on pregnancy disability because I'm doing 2 weeks, so I want to take 2 weeks off. Doesn't really work that way. So we need to have some kind of certification from the medical professional. Same thing if they say I can't show up, on time because of morning sickness or I have to leave, for whatever reason. Make sure you get that certified to make sure that you're following the doctor's directions. We want that note from the doctor, and to make sure that the claim is legitimate as well. Now, the thing with pregnancy disability, a lot of times we think that that ends right at the birth of the child. That is not always the case. So pregnancy disability can be extended beyond the birth date of the child. Again, that depends on what the doctor specified. For pregnancy disability, an employer can have up to 4 months, which is roughly 17 and a third weeks, or 88 days, or 704 hours, however you want to dice that up. Um, and that amount of leave is per pregnancy, not per year. So I'm thinking about what we call Irish twins. Maybe the children are born 10, 11, 12 months apart. That means that for each of those situations, pregnancy disability leave, the full amount applies. It's not per year, it's per birth. Now, leave can be used all at once or it could be intermittent. Again, depends on what the doctor specified. And you can require your employee to use sick leave. However, be aware if they are receiving state disability benefits, then you have to coordinate any or those benefits should be coordinated with what you are paying out. And as I mentioned before, that time for pregnancy disability leave has to be certified by their healthcare provider. So we want that doctor's note. We want that official form that says, hey, this person is disabled due to pregnancy reasons. They cannot perform the essential duties. They need to be off of work, or they need to work a limited schedule or whatever it is. Something that kind of goes along with pregnancy disability is the California Family Rights Act, or CFRA. I like to refer to CFRA really as the California version of FMLA. And because they're really, really similar, right? CFRA basically provides up to 12 weeks of unpaid leave with benefits. So what that means is if you have 5 or more employees, again, there's that magic number 5, and the employee has worked for you for 12 months. Now, they don't have to be 12 consecutive months. It could be just 12 months before their leave and 1,250 hours in the previous 12 months, then they qualify for CFRA protection. And the reasons for CFRA, of course, could be baby bonding, for the birth, adoption, foster care, whatever it is. The employees or family member's serious health condition, caring for a designated person, thinking best friend, childhood friend, neighbor, whatever it is. Um, or for military active duty. Now, thing about the designated person is you can restrict that to one person per 12-month period. In other words, they can't say, well, I'm going to take leave for, my neighbor Bob because he's sick. And, then in 2 months, it's for my childhood best friend that's sick. And then, in 3 weeks after that, it's for my comadre or whatever it is. You can't do that. It's got to be one designated person per 12-month period. Along the same lines, we have FMLA or FEMLA. Again, very similar to CFRA, except this one only applies if you have 50 or more employees. So that's when FMLA comes into play. Very similar to CFRA, it's 12 weeks in a 12-month period, and eligibility is a little more strict for this. So again, this only applies to some of the bigger businesses. The employee has to be in the work location with 50 or more employees in a 75-mile radius, And just like CFRA, they have to have worked for you for 12 months and 1,250 hours in the previous 12 months. Now, the thing about FMLA and CFRA is that as employers, we get to define what 12-month period we're using to measure the leave. And this should be in your handbook. Once you put it in there, that's what we're going to use, right? So a couple methods you can use. The calendar year is probably the easiest one, but it can be a little problematic. And what I mean is if somebody takes 12 weeks this at the end of this year, so they take, say, roughly speaking, October, November, December, and then their calendar resets, then they could take January, February, March of the next year. All of a sudden, you're out unemployed for 6 months of protected leave. So, what we recommend is to use a rolling calendar that starts the first time they use that leave of absence. So, basically, if they start taking leave on February 1st, they take 12 weeks, then the calendar or their bank wouldn't start resetting until February 1st of the following year. And there's a good year to do it too, because we got leap year, so you have that extra day in there. So again, once you pick a method, we're going to use that same method for all of our employees. You can't say, well, I'm going to use this one for, Mary because she's pregnant, and I'm going to use this one for Anna because she broke her leg and she really shouldn't have been playing, frisbee golf or whatever. You have to use the same method for everybody once you pick one. Okay, a few more protected leaves to keep in mind, of course. Here's the list of them: bone marrow, and again, drug and alcohol rehab, school suspension. Again, these are going to depend on how many employees you have. And if you're not sure, go to employers.org. We have a nice little spreadsheet on there that is broken out by number of employees and laws to see which one applies to you. So newest one this year, I had to point out, reproductive loss event. I know last year we had bereavement leave that basically specified we have to give employees 5 unpaid days off for bereavement leave if you qualify for this leave. This year we've added reproductive loss event, and what this means is it applies for miscarriage, failed adoption, that sort of thing. Reproductive loss event is very similar to bereavement leave, 5 days. However, the big difference, or a huge difference with it, is we cannot request any documentation for a reproductive loss event. So if someone comes to you and says they need to take, reproductive loss event leave for a miscarriage or something like that, make sure that we're not asking them for any medical documentation to prove that it happened. I know it's a little, we hope nobody takes advantage of this, given the nature of the leave, but again, be very careful with it. All right, let's move along to some of our wage and hour policies that we should have in our handbook. And a very important thing that we should have when we're talking about wage and hour is defining our work day and our work week. Now, as employers, we have the ability to define when our workday starts. And I'm not talking about shifts, I'm talking about when we're going to start the workday for a payroll purpose. So if you don't pick anything, the state of California is going to say that's fine. We're going to default it to a regular day, which starts at 12 a.m. and ends at 11:59. And for a lot of businesses, that works. However, keep in mind if you have a graveyard shift where those hours overlap that midnight time frame, then you're really working in 2 separate days. So if you have somebody that works from say 8 p.m. until 4:30 in the morning with a half-hour lunch, then the first 4 hours of their shift would fall in today, and the next 4 would fall into tomorrow. Now, when you're figuring overtime or things like that, that can make things a little complicated. So in those cases, you can shift your workday and say, you know what? We're going to say that our workday starts at 4 a.m. instead of 12 a.m. And that's going to make it easier for a payroll department. That's going to make it easier for our employees to understand their paycheck and how overtime works and everything. Same thing happens with the work week. Typically we think of work week, well, we work Monday through Friday, that's our work week. No, that's not what we mean. By work week, we mean how are you going to define the work week for payroll purposes? And this is important because it could affect overtime and how overtime applies. So again, if you don't pick anything, the state's going to say, okay, you're going to default to the regular week, Sunday through Saturday, that's your week. But look at your shifts, look at your work schedule. It may benefit you or simplify things if you shift it over and say, you know what, our work week starts on Monday and ends on Sunday, or starts on Wednesday and ends on Tuesday. Whatever it is, take a look at it to see what makes sense, put it in your handbook. once you decide on what your work day is and what your work week is, it's not something that you're going to change every month or every couple of weeks or whatever. Once you have it set in there, make sure that it stays put unless you have a really, really good reason for changing it. Okay. And again, this is important because it could have a bearing on how overtime is figured, whether it's for the day or for the week, right? I'm talking about time and a half, double time, that sort of thing, especially when we get to the question of, working 7 days in a row. Now, a lot of people think that, hey, if I work 7 days in a row, on that seventh day, I get overtime for all my first 8 hours and then double time for anything past that. Well, keep in mind, that is only if you work 7 days in the same work week. And that's why it's so important to define what your work week is. So, for example, if your work week is from Sunday through Saturday, and you have somebody work from Monday until the following Monday, that's what, 8 days or whatever it is. And they could say, well, hey, I worked 8 days in a row, so my seventh day should have been whatever. Technically, no, because if your week is from Sunday through Saturday, then the first week you only work 6 days from Monday through Saturday, and then the next week started. So I guess if you do the math, you could have somebody work up to 12 days maybe without running into that seventh day penalty, depending on what the days are. So yeah, that's why it's so important to define what your work week is and what your work day is. And of course, if you're employing the minors, be aware because they could be subject to different restrictions as to how many hours they can work per day. Now, speaking about meal and break periods, I mean, these are always or continue to be a way that we see employers get in trouble, either not giving, not giving breaks, employees not taking their meal breaks on time, not paying the penalties or the premium, that sort of thing. And the important thing we could recommend on this is make sure that your managers, your supervisors, your leads, your foremen are aware of what the rules are. Now, the rules should be in your handbook. Make sure that anybody in the supervisory position, all the way down to a foreman or lead or whatever it is aware of what they are and what they should be allowing and how they should be enforcing. The thing about it is, when it comes to breaks, it's our job as managers to authorize and permit the employee. In other words, we're not the break police. All we have to do is authorize them and give them the opportunity to take that break. If they choose not to, if they work through it or whatever it is by their own volition, and this is just a rest break, this is a 10-minute break, then that is on them, right? They're not clocking out for rest breaks. And the important thing about breaks, though, is we can't require employees to stay on the premises. We can't say you can take a break, but you can't leave the break room or whatever. Because the thing is, we have to basically relinquish all control over the employee during their rest and meal breaks, right? That's their time. So if they want to jump in their car and speed over to the gas station to get a soda and a hot dog or whatever during their 10-minute break, that's fine. We can enforce the break and say you have to be back in your work area within, you know, 10 minutes or 15 minutes of your break starting, but we can't restrict what they do during that time. Same with lunch breaks. We cannot restrict what they do during their lunch break. We have to relieve them of all job duty. So we can't say, hey, take your lunch, but stay at the front desk and answer the phones in case somebody calls. Because at that point, we are not relinquishing control over them. We're not relieving them of all job duties. So it's not a true lunch break at that point. Now, penalty for failing to provide a lunch break or for shorting people on lunch break is 1 hour of their regular rate of pay per day. And something to keep in mind too, for meal breaks, it's a minimum of 30 minutes taken before the fifth hour. So again, for if they work more than 5 hours. So again, we want to make sure that it's before the end of the fifth hour of work. In other words, 4 hours and 59 minutes in. So I know that's a little confusing, right? And just the wording of the state is very confusing on that one. But just keep in mind, before they hit their fifth hour of work is when you want them to start their meal break. Of course, number of meal breaks is going to vary based on how many hours they work per day. So anybody that works over 10 hours a day is authorized to take a second meal break. Now, they can waive that second one if they work less than 12 hours, but make sure that that is documented that they chose to waive that second meal break. So some tips for meal and rest breaks. Again, make sure the employee is able to leave the premises. You can say that they have to be at their workstation at the end of the break. That's fine. But whatever they do between that time, that's on them. If an employee misses their breaks, make sure that you let them know they have to notify their supervisor and document the reason why. whether it's because they forgot about it or whether it's because the production line never stopped or because they got a call, whatever it is, make sure that that's documented. And what we mean by rounding reminder is the state of California states that when it comes to meal breaks, we cannot round those punches. And overall, we discourage rounding, you know, whether it's meal breaks or whether it's the start or the end of the shift, especially if you have the ability to measure things down to the minute. So if you have an electronic time clock or something, we cannot iterate enough how important it is not to round that time because you could be inadvertently shorting your employees' time, or they can claim that you are, and then things get a little messy. All right, let's talk about some benefits and expectations as well, which should also be present in your handbook. And the first one is vacation. If you offer vacation, there are certain things that you should have in place. Notice I said if you offer vacation. The state doesn't say that we have to give vacation. There's no law that says we have to give our employees paid vacation. So be very aware of that. Sometimes, we have employees say, "Oh, well, by law, you have to give me vacation." No, we don't. However, if we do give vacation, there are certain things that the state says we have to do. First thing is the state considers vacation time to be earned wages. So what this means is that once they are awarded, once it's earned, we can't take it away. In other words, we can't have a use it or lose it policy that says, hey, if you don't use it by the end of the year, your vacation is gonna go away, it's gonna zero out. We cannot do that, right? State also says if you're under the accrual method, you can establish a reasonable cap that says employees do not accrue any more vacation after they hit this amount. What do they mean by reasonable cap? What they've defined as a reasonable cap is 1.5 to 2 times their annual accrual rate. So in other words, if somebody accrues 80 hours a year, a reasonable cap would be 120 hours. That's 1.5 times the 80 hours they accrue per year. Vacation, of course, being wages, means that it is earned, that can't go away. So if you terminate somebody or they resign, they are due their vacation, any accrued and unused vacation at that time. And be very careful if you give personal days, floating holidays, personal holidays, whatever they're called, because if they are not tied to a specific day, then the state considers them to be vacation and subject to the same protections. In other words, if you say, well, I'm going to give people a personal holiday for their birthday every year and they have to use it on their birthday, that's fine. That's tied to one day. If they don't use it or if they're terminated before it, they're not owed it. But if you say I'm going to give you a personal holiday that you can use whenever, that's just vacation by a different name. And if you terminate somebody and they haven't used that floating holiday, that's due to them at the time of termination. Right, now, when it comes to drug-free workplace policies, which you should also have it in your handbook, we recommend that all employers have a drug-free workplace policy. And really, the important thing about this is letting your employees know if you have any kind of testing in place. So, for example, reasonable suspicion testing. We want to make sure that you have a statement on there that lets them know, that they are subject to reasonable suspicion testing, right? Random drug testing we can't do except for certain employees that are regulated by law to do so, like DOT drivers, for example, or safety sensitive jobs. Some of those you can do random drug testing. For general industry, you cannot do that in California. Now, there's no law that says that you can't do a disciplinary action for employees that are under the influence of drugs or alcohol at work. So even if there is protection for use of drugs or alcohol outside of work, there's nothing that says that they can be under the influence or have possession of it at work, and you can still enforce that, right? So again, there are substance use protections, but not on the job use. So whether it's a disability, sometimes we hear a lot that, hey, well, alcoholism is considered disability. That doesn't mean that the employee can be drunk, drinking, or have a six-pack at work. That's not how that works. Now, I alluded to cannabis use rights. Off-site and off-duty cannabis use is now protected in the state of California, which means you can't discriminate or take adverse action against an employee for using cannabis while they're off the job. Now, again, this doesn't allow employees to go, light up at break time or at lunchtime or anything. That means that whatever they do off duty is their business, but they cannot be under the influence at work. And there are exceptions to these protections, though. So anybody that's in the building and construction trades, or when testing is required by state or federal law, again, that's like those DOT drivers, then these protections do not apply. So the big change with these cannabis use protections, of course, came in on the testing side, how we test for do drug screenings for reasonable suspicion or anything, because the old urine tests do not work when it comes to cannabis testing because they detect non-psychoactive ingredients. So you want to make sure that you're working with your testing clinic or whoever you use to make sure that they are up to date on cannabis testing and that they are compliant with the new law. So have that conversation with them. Make sure that that's in place. Now, when it comes to disciplinary policies, of course, we recommend presenting discipline as a guideline rather than required steps. In other words, you don't want to lock yourself into a three strikes and you're out policy for everything, right? We want to make sure that you say, hey, any violation of policy could result in disciplinary action up to and including termination. Some of the possible steps we may use are, and then you list, verbal, written, suspension, whatever it is. But you don't want to say, your first infraction will be a verbal, your second infraction will be a written, your third infraction will be a suspension, your fourth will be termination, because that could be interpreted as saying you're going to get four chances no matter what you do. So again, just give those suggestions as to what those steps could be and give yourself the ability to apply them as needed. Again, we got to talk about employment being at will and mention as a, throw that statement in there that any violation of company policy could result in disciplinary action up to and including termination. I also recommend having some integrity policies. These are the ones that basically give guidelines on conduct for our employees. So we're going to talk about open door policies, make sure they know where those complaints are going to go. Conduct and attendance, drug and alcohol testing, workplace violence. That is not always related to harassment or discrimination. So make sure you have that policy out there, along with weapons, electronic communication, solicitation, dating in the workplace and outside employment, moonlighting. You can restrict that to a certain point. You can say you can't work for a competitor, or you could say, you can work for another company, but we expect this to be your primary responsibility or something along those lines. So be very, you can make sure that you include these as needed for your organization. Now, when it comes to company social media accounts, it's also a good idea to put something in there about who can access them, who can represent themselves as representatives of the company or speaking for your company as well. The use of mobile phones, we can restrict that to a certain extent, right? We can say you should not use those while you're on duty. While you're on break or lunch, feel free. But if you're, running a big piece of equipment, if you're on a forklift, we probably don't want you scrolling through Instagram or Facebook or whatever while you're doing that. How do you report injuries? Again, the handbook is a great place to put that in there, as well as how to deal with company property. In other words, who can take things off-site and who needs to be authorized or give the authorization for it. Right. Something that happened recently too that affects our handbooks and policies is the Stericycle decision that came across from the National Labor Relations Board. And when we hear about the National Labor Relations Board or National Labor Relations Act, we tend to think this applies only to union environments. That is not true, though. Section 7 protects all employees, and this is what allows employees to talk about their wages, to talk about their work conditions without any kind of retaliation. So what the Stericycle decision did was it said if there's a rule or a policy that has and I quote, reasonable tendency to chill employee exercise of their rights to discuss wages and other terms and conditions of employment, they're going to presume that it's unlawful. So in other words, if you have an old handbook, take a look at your policies to make sure that they're not overreaching or overbearing. It seems like they're, designed to silence your employees from talking about these things. And again, things not to include in your handbook, probationary periods, because they could be seen as a guarantee of employment for a certain time. Disciplinary procedures that lock you into the 3 strikes or 4 strikes and you're out. Policies that imply job security, basically something that changes the at-will nature of the job. In-depth supervisor and manager information. Again, that's for a policy and procedure manual, not for a handbook. Same with benefit plans. Benefit plans change year to year, so maybe not the best place to include that information, as well as pre-employment practices. Your handbook is for your current employees, not for your prospective employees. We recommend if you have that open door policy, another good tool would may be an employee hotline. Give them a way or an avenue to express any kind of concerns outside of going up the regular chain of command. And that could be good for employers because, you can be made aware of issues that you may otherwise not know of because people don't want to come to you. So things to check your handbook for this year. Make sure all your leaves of absence are up to date. If you have reasonable suspicion testing, make sure the language reflects these new changes. Rest periods and breaks, harassment policy, make sure you update those protected classes. Gender specific references, make sure your handbook is gender neutral. And finally, a language that could violate that National Labor Relations Act. Any language that's overbearing that says you shouldn't talk to your co-workers about anything work related. That's a little overbearing. But if you say something like, you shouldn't share any company procedures with outside companies, that's a little more acceptable. So some reminders for you before I go. Make sure you review your handbook, distribute it, right? It doesn't do you any good to have a handbook if you don't pass it out. Make sure you're sticking to it and you're training your managers on your policy so they help you enforce it. And don't forget, update your labor law posters, your injury and illness prevention program, and your COVID-19 plan. We're still required to have those, so those are living documents. Make sure you're updating them on a regular basis. Now, if you're with us for continuing education credits, I do have some codes for you. For HRCI, it is 651642. And for SHRM, we have 24-2NYR6. Don't forget that dash. Otherwise, SHRM will come after you. No, SHRM doesn't like if you forget that dash. So with that, I'll hand it off to Anna. We are coming in right on time, it looks like. So I'll let you wrap it up for us.
Awesome. Thank you, Eli, for that hour full of information about our handbook. I did just drop a link into the chat for that quick survey that helps us, continue to develop these resources, and we share that information with our partners at Monterey so that they can do the same and make sure that you guys have all the tools that you need. If you also scroll up in the chat, I did drop a link to the next training that's coming up on March 6th. That will be communications in the workplace. That's a really great training by one of our lead trainers, Keisha. And then I also dropped the Monterey County HR hotline. That's a free hotline, 888-217-6899. Thank you to Pearl and Laura and the entire team at Monterey for bringing this together. And we look forward to seeing you all in March. And please take your survey and we'll see you then. Cheers.
Thank you.
Thank you.